My name is Elaine Marsh, and I am 36 years old. I have been a licensed estate attorney for 9 years. I have sat across tables from grieving families and helped them understand what their loved ones left behind. I have read wills that divided siblings and trust documents that reunited them. I know better than most people that money is never just money inside a family. It is a language. It is a vote. It is a way of saying who matters and who doesn't, without ever having to say the words out loud. I say all of that so you understand that when I tell you I missed what was happening in my own marriage for nearly 7 years, I am not telling you a story about being naive. I am telling you a story about being too close to see clearly, and about what happened on the Tuesday morning in October when I finally looked. What I found changed everything. Not just my marriage, not just my finances, my understanding of 7 years of my life. The version of myself that had walked into the Calloway family, telling herself she just needed to try harder, be warmer, give it more time, that version did not walk out. But I want to start at the beginning, because the ending only makes sense if you understand where I started. I grew up in a small town in rural Ohio called Grayfield. Population 4,000, one stoplight. A diner called Patty's that served the same 3 breakfast specials every day for 40 years. My mother, Ruth, was a school librarian. My father, Donald, drove a delivery truck for a regional grocery chain. They were not wealthy people. They were careful people. My mother kept a notebook in the kitchen drawer where she tracked every dollar that came in and every dollar that went out, not because she was anxious about money, but because she respected it. She had grown up with less than she had as an adult, and she never forgot what less felt like. I learned to read from library books my mother brought home in paper bags. I learned to work from watching my father leave the house at 4:30 every morning without complaint and come home at 6 with the particular tiredness of a man who had earned his day. I was the first person in my family to go to university, not because my parents pushed me, but because I was the kind of child who pushed herself, who looked at the world outside Grayfield and felt the pull of it so strongly that staying still felt like holding your breath. I went to Ohio State on a combination of scholarships and loans I spent 8 years paying back. I studied pre-law because contracts made sense to me the way stories made sense to other people. A contract is just an agreement written down, so no one can pretend it said something else later. I found that clarifying. I still do. I graduated at the top of my class, passed the bar on my first attempt, and took a position at a mid-size estate planning firm in Columbus. I was 24 years old, 400 miles from Grayfield, and I believed entirely that the work would be enough. Then I met Daniel Calloway. He came into our office as the executor of his grandmother's estate. He was 31, tall, with the easy confidence of someone who had grown up being told he was exceptional and had mostly lived up to it. He was a commercial architect. He designed buildings that won regional awards and appeared in trade publications. He talked about his work the way I talked about mine, with genuine affection, not performance. We had coffee after his second appointment to discuss the estate. We had dinner after his third. By the time the estate was settled, we were together. I want to say I noticed the family early, and I did notice things. I noticed that Daniel spoke about his mother, Patricia Calloway, with a particular kind of deference that was different from love. Love is warm and complicated. Deference is smooth and slightly absent, like the way you repeat a habit you formed so young you no longer question whether it makes sense. I noticed that when we drove to his parents' house in Westerville for the first time, Daniel adjusted his posture in the car as we got close. The way people do when they are preparing to be assessed. I noticed that his mother, when she opened the door, looked past me to him first and only brought her eyes to me after she had confirmed whatever she needed to confirm from his face. I noticed these things, and I filed them under adjusting to a new family and gave it more time. We married 3 years after we met, in the September of a year when the weather was perfect, and our life together felt like a room I had spent a long time looking for, and finally walked into. The wedding was at a vineyard outside Columbus. 80 guests, a string quartet, flowers I had chosen myself from a farm stand outside of town. Daniel's mother wore a cream dress that was, I realized in the photographs later, the same shade as mine. I told myself she had not done it on purpose. I still am not certain. The first clear signal came at the rehearsal dinner the night before. Patricia had organized it herself, which I had been grateful for at the time because my own parents were driving in from Grayfield and I had enough to manage. She stood up to give a toast. She spoke for 4 minutes about Daniel, his childhood, his achievements, the pride she felt watching him become the man he was. She spoke about what she hoped for his future. She did not say my name once. Not once in 4 minutes. The the night before her son's wedding to me. Daniel's father, George, caught my eye across the table. He had a look on his face I would come to know well over the following years. A helpless, apologetic look, the look of a man who has been watching this for a long time and has run out of ways to address it. He raised his glass slightly in my direction. I raised mine back. That was the most honest exchange we had that entire weekend. I told myself it was her way. I told myself she was nervous. I told myself she would warm up. I married Daniel the next afternoon in a vineyard, and I was genuinely, completely happy. And I do not want you to lose that in what comes later. I loved him. And that love was real. That is what makes the rest of it complicated. Patricia Calloway was not cruel. I want to be precise about this because cruelty would have been easier to name and address. She was something more sophisticated. She was selective. She gave warmth the way a careful person gives expensive gifts, thoughtfully, strategically, in amounts that created appreciation without ever creating sufficiency. She was warm to Daniel, always and completely. She was warm to her daughter, Renata, who was 34 to my 29 when I entered the family, and who had her mother's jawline and her mother's talent for arranging things in ways that served her purposes without appearing to do so. She was warm to Daniel's childhood friends, to the neighbors she had known for 30 years, to the women in her book club and her garden committee. To me, she was something I struggled to name for a very long time. I eventually settled on managed. She managed me. She was polite and occasionally kind and always slightly out of reach. And the distance was never large enough to point to, but it was consistent and it was maintained with a precision that suggested deliberate effort. The introductions were the clearest expression of it. For 7 years, in every social context, Patricia introduced me as Daniel's wife. Not as Elaine. Not as Daniel's wife, Elaine. Just Daniel's wife. The way you'd refer to someone whose name you keep forgetting, or don't consider important enough to repeat. At her garden committee, when I had been attending for 3 years. At the country club Christmas dinner, where I sat beside Daniel and spoke to the people around me and was apparently still a woman without a name. At George's retirement party, in front of 60 people, many of whom I had met a dozen times, many of whom knew my name perfectly well and simply watched while Patricia introduced me and did not offer it. Daniel always filled it in afterward. He would say her name is Elaine, with a slight laugh that was meant to soften it. He said this so many times over 7 years that it became its own kind of sentence. A sentence that said, "This is a pattern we have agreed not to confront." I was practicing estate law the whole time. 7 years of sitting across from families and helping them understand what had been taken from them, what had been hidden from them, what they were owed and had never received. 7 years of being very good at seeing the structures other people couldn't see. And inside my own house, I was filing everything under "it's just her way," and she'll warm up eventually, and I just need to try harder. The specific blindness of loving someone is that it makes you extend charity to the people adjacent to them that you would never extend to strangers. I would have seen it in a client's file in 40 minutes. It took me 7 years to see it in my own life. And even then, I did not see it because I finally grew wise enough to look. I saw it because of a mortgage application. In the spring of the 7th year of our marriage, Daniel and I decided to refinance our house. The house was in both our names. Bought the 2nd year of our marriage with a down payment that came from my savings, my 8 years of loan payments, my careful notebook keeping that I had learned from my mother in the kitchen in Grayfield. We had paid down a significant portion of the principal, and the interest rates had dropped enough to make refinancing sensible. I started the application on a Tuesday morning when Daniel was at his office. Routine process. I had done refinancing applications for clients many times. I pulled our financial documents, our tax returns, our account statements, and I began filling in the relevant fields. The joint account was straightforward. Our individual accounts were straightforward. And then I got to the line for outstanding liabilities. And I found something that was not straightforward at all. There was a line of credit in my name that I had not opened. I read it again. I checked the account number. I checked the originating institution. I called the bank. I was on hold for 11 minutes. When the representative came on the line, she confirmed the account, opened 4 years ago, associated with my name, my social security number, my date of birth, and a mailing address I had not lived at since before my marriage. The current balance was $73,000. $73,000, borrowed in my name over 4 years. I sat at the kitchen table for a long time. The coffee I had made before I started the application was cold. I looked out the window at the backyard. Daniel and I had spent 2 weekends landscaping the previous summer, and I thought about every piece of paper I had ever signed in this marriage, and whether I had read all of them carefully. I am an estate attorney. I read everything carefully. Except, I realized, the things that had been handed to me inside the ordinary flow of daily life. The insurance update, the joint filing amendment, the signature on a document at Patricia's house the Christmas 3 years ago, at her kitchen table, with people talking around me and a glass of wine in my hand, and Patricia saying, "It's just the annual family trust update. Daniel needs both your signatures. It's a formality." I had signed it. I had not read it. That was the only time in 7 years I had not read something before I signed it. I have thought about the timing of that a great deal since. I did not call Daniel. I did not call Patricia. I went to my office, closed the door, and spent the next 4 hours doing what I knew how to do. I pulled every document I could access. I called the bank and requested a full transaction history, citing my professional capacity and my legal right as the named account holder. I requested the original account application. I logged into every joint financial account we had and pulled a year of statements. I was not looking for a specific thing. I was mapping the architecture, the way I mapped it for clients. Start at the beginning, follow every dollar, let the pattern show itself. The pattern showed itself within 2 hours. The line of credit in my name had been opened 4 years ago with documentation that had my signature on the original application. The signature was close to mine. It was not mine. The mailing address was a P.O. box registered to a company called Callaway Family Holdings, LLC. I had never heard of Callaway Family Holdings. I searched the Ohio Secretary of State's business registry. Callaway Family Holdings was a limited liability company registered 5 years ago. The registered agent was Patricia Ann Callaway. The secondary member listed was Renata Callaway Marsh, Patricia's daughter. Daniel was not listed. I was not listed. I pulled the transaction history on the line of credit. $73,000, drawn in irregular amounts over 4 years, always between $8,000 and $14,000 at a time. I cross-referenced the draw dates against my own calendar. 4 of the 7 draws had occurred in the week immediately after I had signed something inside the Callaway household. The connection was not a coincidence. Coincidences in financial documents are almost never coincidences. They are timing. I sat back in my chair. I thought about 7 years of being Daniel's wife at dinner tables and garden committees. I thought about Renata, who had never been openly unkind to me, but who had always stood slightly closer to her mother than the situation required. A quiet alignment. I thought about George, with his apologetic looks and his slight glass raises. I thought about Patricia saying it's a formality and sliding a piece of paper across a table while people talked around me. Then I called Frances Donahue. Frances was a colleague I trusted more than anyone I knew professionally. 20 years my senior, a forensic accountant who had worked financial crime cases for 18 years before going private. I told her what I had found. She listened without interrupting. When I finished, she said, "How soon can you get me the full transaction history?" I said, "I'll send it tonight." She said, "And the corporate registry for Callaway Family Holdings?" I said, "Already sent." She said, "Elaine?" I said, "Yes." She said, "This is going to take me about a week to map fully, and I think you should talk to a family attorney before you say anything to your husband." I said, "I know." She said, "I mean it." "Before anything?" I said, "I know, Frances." I said it again. "I know." I hung up and sat in my office in the building where I helped other people understand what had been taken from them. And I let myself, for the first time that day, feel the weight of what I was looking at. Not for long. There was work to do. But for a few minutes, just that. The week Frances spent mapping the account was the strangest week of my life. I went home every evening and cooked dinner and sat with Daniel and talked about his projects and listened to him describe a building he was designing on the west side of Columbus, a mixed-use development with a courtyard garden he was particularly proud of. He was enthusiastic and detailed and completely himself, the man I had loved for 10 years, and I sat across from him and nodded and asked questions and felt the distance between what I knew and what he knew like a physical thing in the room between us. I did not know yet whether he was aware of what his mother and sister had done. That was the question I sat with every evening. The question I could not answer until Frances finished her work. I did not want to be wrong about him. I also did not want to be naive about him. I had spent 7 years being naive, one way or another, and I was finished with it. Frances called on the 8th day. She had the full picture. She walked me through it on the phone with the precision I had always admired in her. No drama, no excess, just the architecture laid out clearly so I could see its shape. Here is what she had found. The line of credit in my name had been opened using my personal information, obtained through means she could not fully trace, but that almost certainly involved access to documents I had provided in good faith to the Calloway family over the course of the marriage. Tax returns, insurance documents, the joint filings. Somewhere in 7 years of administrative family paperwork, my information had been extracted and used to establish a credit line whose funds went directly to Calloway Family Holdings. The money, $73,000, had moved from the credit line into the holdings account, and from there into three separate streams. $41,000 had gone to what appeared to be home renovation costs on Patricia and George's property. $18,000 had been transferred to a personal account registered to Renan. $14,000 had been used for expenses Francis described as personal luxury spending, including travel, retail purchases, and a significant amount at a jewelry store in downtown Columbus. Not $1 had gone to Daniel. Not $1 had gone to our joint household. $73,000 borrowed in money over 4 years, spent entirely by his mother and his sister, while I sat at dinner tables being introduced as Daniel's wife and signing things I was told were formalities and wondering why the one had never quite come. I sat with her. Then I contacted a family attorney named Harriet Lee, who had an office on High Street and whose reputation for forensic precision in matrimonial matters was known throughout the Columbus legal community. I sent her Francis's full report before our first meeting. I walked into her office on a Friday afternoon, every document organized, every transaction flagged, every timeline mapped. She looked at the file for 20 minutes while I sat across from her. Then she looked up and said, "You did all of this yourself." I said, "It's what I do." She said, "Then you already know what you have." I said, "I wanted a second set of eyes." She said, "You have a fraud case, potentially a criminal one, depending on how the DA's office wants to approach the signature on the original application. We need to talk about your marriage." I said, "I know." She said, "Does your husband know?" I said, "I don't know yet." She said, "That matters enormously, both legally and personally." I said, "I know that too." She said, "When are you planning to speak to him?" I said, "This weekend." She nodded. She handed me back the file. She said, "Call me Saturday evening, whatever happens." I told Daniel on a Saturday morning. We were at the kitchen table, both of us with coffee. The particular ease of a weekend morning that I had always loved about our life together, the unhurried quality of it. I put the file on the table and I said, "I need to show you something." He looked at it the way people look at something unexpected, without yet knowing whether to be alarmed. He picked it up, he read it. I watched his face. I have studied faces for 20 years, in grief and in relief, and in the specific expression people wear when they receive information they already knew was coming. Daniel's face did not have that last expression. What he had, as he turned the pages and read Francis's findings and saw the transaction history laid out in clean columns, was the expression of a man encountering something he genuinely had not known and finding it almost impossible to absorb. His color changed, his jaw set and then released and then set again. He put the file down after about 10 minutes and he looked at the table for a long time before he looked at me. He said, "How long have you known?" I said, 2 weeks. He said, "Why didn't you tell me immediately?" I said, "Because I needed to know the full scope before I said anything, and because I needed to know whether you were part of it." He went very still. He said, "Elaine?" I said, "I know." I said, "I don't believe you were." But I had to be sure. He said, "I wasn't." His voice was quiet in a way that had nothing to do with volume. He said, "I promise you, I did not know this." I looked at him. I had been looking at him for 10 years, and I believed him, and I also understood, with a clarity that felt like cold water, that believing him did not undo what had happened. That believing him did not account for 7 years of it's a formality, and Daniel's wife, and the particular practiced distance that his mother had always maintained between me and the full reality of this family. He had not known about the fraud. He had known, at some level, about everything else. The space between those two things was enormous, and was going to take us a very long time to navigate. He said, "I'll call her." I said, "You won't." "Not yet." He looked at me. I said, "We do this correctly." He understood what I meant. He was married to an estate attorney. He understood that correctly meant documented and sequenced, and not driven by the immediate need to confront someone before the paperwork was in order. He put his hand over mine on the table. I did not move mine away, but I did not move it toward him either. I just let it stay where it was, still and separate, while we both sat with the specific weight of what came next. I filed a formal fraud report with the Columbus Police Department on the Monday after I spoke to Daniel. I also contacted the Ohio Attorney General's Consumer Protection Division, citing the forged signature on the original credit application. Harriet filed a civil claim on my behalf against Callaway Family Holdings, naming Patricia Callaway and Renata Callaway Marsh as respondents. The credit line was frozen pending investigation. My name and credit record were flagged for review and correction by the three major credit bureaus. Frances submitted her full forensic report to the civil court. I also, because I am thorough, had a document examiner review the forged signature on the original application. He confirmed in writing that the signature was not mine. He identified three specific characteristics that differed from my verified signature samples in ways that were consistent with deliberate imitation rather than organic variation. He had been doing this for 30 years. He was very certain. The civil proceeding moved at the pace civil proceedings move, which is to say slowly and with considerable paperwork. I did not mind the paperwork. I had been doing paperwork for 20 years, and I found it clarifying. Each document filed was another brick in the wall between what had happened to me and the version of events Patricia would have preferred. She could not rewrite a forensic accountant's report. She could not rewrite a document examiner's findings. She could not rewrite the transaction history, or the Secretary of State's business registry, or the P.O. box connected to her family's LLC. She was very good at rewriting things in conversation, at the dinner table, at social events. The legal record did not give her that room, and I had known from the beginning that the legal record was where this story needed to be told. Daniel called his mother the week after I filed. I was not in the room. He told me afterward that it lasted 18 minutes, that she had started with denial, then with explanation, then with the specific argument that I was overreacting, and that it was family money, and that the arrangement had been temporary, and she had always intended to repay it, just in her own time. He said he had asked her one question. Did you use Elaine's information without her knowledge to open an account in her name? She had not answered the question directly. That was his answer. He came back into the living room and sat down and said, "My mother did this." I said, "I know." He said, "I need you to understand that I did not." I said, "I do understand that. I also need you to understand that your mother spent 7 years treating me like a guest in this family, and the way she treated me made it easier for her to take from me, because she had always made clear that I was not quite fully in." He was quiet for a long time. Then he said, "You're right." And I let it go on too long. I said, "Yes." He said, "I don't know how to fix that." I said, "I know." I said, "We have to start with the truth, and the truth is going to be uncomfortable for a long time, and the only way through it is straight through it." He nodded. We sat in our kitchen in a marriage that was still ours, but that needed now to be deliberately rebuilt on a foundation that had been cleared of everything that had been built on concealment. That is slow work. It does not make for a clean ending. But I am an estate attorney. I know that the most important documents are not the ones that announce grand beginnings. They are the ones that clearly record what is real, what is owed, and what was agreed to. We were starting from a real document now, one that neither of us could pretend said something. It didn't. I want to tell you what happened with Patricia, because I think it matters how it happened. It happened in Harriet's conference room, 4 months after the civil filing, on a Thursday morning in February. Harriet and I on one side, Patricia and her attorney on the other. I had seen Patricia twice in those 4 months, both times briefly at events we could not both avoid. Each time she had looked at me with an expression that I recognized, having seen it many times in my professional life, as the expression of someone who is waiting to see whether you will blink first. I had not blinked. I was not going to blink. In Harriet's conference room, Patricia's attorney made 3 arguments. The first was that the signature discrepancy was attributable to clerical error. The document examiner's report was presented. Her attorney read it and did not repeat that argument. The second was that the funds had been borrowed on an informal family basis with the expectation of repayment. Harriet cited the corporate registry, the P.O. box, and the transaction trail, showing the money flowing to personal luxury spending. That argument also did not survive contact with the documentation. The third was that no harm had been done to my credit because the account had been maintained in good standing. My credit report was presented, showing 3 hard inquiries over 4 years related to the fraudulent account, each of which had affected my credit score during the periods when I had not known to address them. That argument did not survive either. The settlement that followed was not one I will detail publicly. What I will say is that the line of credit was fully satisfied. My credit record was corrected, formally and completely. The costs of the civil proceeding were addressed, and there was a formal legal acknowledgement, signed and notarized, that the account had been opened without my knowledge or authorization. Patricia signed it, in person, in a room where I was sitting across from her. She did not look at me when she signed. She looked at the document the way someone looks at something they are being required to absorb but are not yet willing to acknowledge. Her attorney gathered the papers. Harriet gathered ours. Patricia stood to leave. At the door, she stopped. She did not turn all the way around. She said, "I hope you understand that I did what I thought was best for this family." I said, "I understand that you believe that." She left. I sat in Harriet's conference room for a moment after the door closed. Harriet refilled my coffee without asking. We sat there, both of us, and did not say anything for a minute. Then Harriet said, "How are you?" I said, "I'm all right." She said, "You know, most people who come through my office spend years wondering if they could have caught it sooner." I said, "I have spent time on that." She said, "And?" I said, "I am an estate attorney. I know that the question after something like this isn't whether you missed it. The question is what you build on the cleared ground." She nodded. She drank her coffee. I drank mine. Outside the window, Columbus was going about its February in the particular gray that February specializes in. I had work to do. I had always had work to do. I picked up my bag and I left. Here's what I want to tell you, in place of a tidy ending, because I don't have one and I don't think I'm supposed to. Daniel and I are still married. That has been, and continues to be, the result of deliberate daily choice on both our parts. We are in the process of building something that is more honest than what we had, which means it is also more uncomfortable in the ways that honesty is always uncomfortable when it replaces something easier. He has a better understanding now of how his family operated and of his own role in maintaining it. That understanding did not come all at once. It comes in pieces, the way understanding usually does when you're looking at something you spent a long time not looking at. He is trying. I am trying. Some days we are very good at it. My mother-in-law and I have not spoken since the Thursday in February. I don't know what that means for the future. I know what it means now, which is that I have, for the first time in 7 years, a completely accurate picture of who I am in relation to this family and what I am owed and what I choose to give, and that picture is built on documents that cannot be revised by anyone's preferred version of events. My mother, Ruth, came to visit us this spring after everything resolved. She sat at my kitchen table and I told her most of it. Not every detail, but the shape. She listened the way she always listened, with her full attention and without rushing toward a verdict. When I finished, she was quiet for a moment. Then she reached across and put her hand over mine and said, "I'm glad you looked." I said, "I should have looked sooner." She said, "You looked when you could see." I sat with that. She got up to make more tea. I looked out the window at the courtyard garden Daniel had planted the previous autumn, the one he'd designed with the same care he brought to the buildings he loved. Roses that wouldn't bloom until June, and bulbs that wouldn't show for another month, and bare soil in between that was, even then, doing the work it needed to do, quietly, under the surface, in preparation for what came next. I have been a lawyer for 9 years. I know that every document worth having is built on honest ground. What I am building now is the most important document of my life. I intend to read every word. That's my story. 7 years, 1 line of credit, and the Tuesday morning I finally looked at the paperwork. If this reminded you to read what you sign, to look at what you're told is a formality, to check whose name is on the things you carry, take that as your sign. Do it this week. Not because you suspect something, but because you deserve to know. Share this with someone who needs to hear it. Drop a comment, hit subscribe, and I'll see you in the next one.